Good morning, everybody, and welcome to this morning's webinar in which we'll be talking about tackling compliance issues in and around AI-based hiring and firing. And we'll also be touching on some generic AI content as well and answering questions as they come in. We've got a really strong expert panel for you today from across different disciplines within the organisation, and I'm your host, Rich Jackson. We've got Peter Jones, Partner in Employment Law at SGD Law, Megan Mirza, Senior Data Protection Officer within the Moore Kingston Smith Data Protection Services team, and our colleague Ian Inman, also Data Protection Officer within the Data Protection Services team. So if I could hand over to you, Peter, to kick us off with introductions, that would be great.
Okay, thanks, Rich, and good morning, everyone. Yes, does what it says on the tin. I'm an employment law solicitor as part of Moore SGD Law, which is a full-service law firm within Moore Kingston Smith, delivering on all commercial areas of law. And I have a particular interest in AI matters as it's a very interesting and dynamic area, and obviously has a huge potential impact on employment and also employment practices. So over to Megan.
And good morning, I'm Megan Mirza, Senior Data Protection Officer in our outward-facing Data Protection Services team. We provide support, advice, and some hand-holding to the clients we work with in terms of compliance. Previously, I've worked at the Information Commissioner's Office, and I'm very interested in how AI is being used in the context of recruitment and the impact that that has on individuals, positive or negative. So yeah, we're looking forward to exploring this in more detail.
Yep, and my name's Ian Inman, and I'm a Data Protection Officer in the Data Protection Services team. I work with Megan, very scarily similar background actually. I also worked with the ICO for 10 years, and obviously much like Megan, we work with a range of clients to help them comply with data protection law.
Brilliant, thanks everyone. So we've got a fair amount to cover in today's session, and very far-ranging in scope. But what we'll start off with initially at the beginning of the session is a bit of an overview of the definition of AI and artificial intelligence and what that actually is, because I think it's really important to set that foundation stone in place so that everything we talk about during today's session comes with that understanding of what AI actually is. And then we'll move on to looking at the use of AI in recruitment and how the current legislation may apply to that. And then we'll be thinking about considerations when implementing, adopting and deploying AI. And that's something that as a data protection services team, we are working increasingly on each week and almost every day at the moment with clients that are looking to adopt or have adopted the use of AI and are concerned about whether they're doing it in the right way and whether they've covered all of their due diligence, etc. And then we'll talk about the risks of getting implementation wrong in terms of the regulatory action and litigation. And then towards the end of the session, we'll think about some measures for risk reduction and reaping the benefits of AI. And then everyone will have an opportunity to ask us some questions at the end of the session. So what is artificial intelligence, and what is AI, and what does it mean to all of us? And this may seem a surprising slide with the outline of a dinosaur that I'm reliably told is not a T-Rex, although it looks like one, but some food for thought, and a quote that some of you may be really familiar with, and one that I'll invite Ian to give some thoughts on.
Yeah, I really like this quote. I've been using this quote for a long time now, maybe as long as 13 or 14 years. Obviously, it's the Ian Malcolm quote from Jurassic Park, hence the dinosaur on the background. But I think it really sort of encapsulates the tension, if you like, between the use of technology. And I say technology because when I first used this quote, we were talking about CCTV, then body-worn video, then drones, then it was facial recognition. Every time a new bit of technology comes along, I like to dust this quote off and reel it out. Because that's really what it's all about, isn't it? These things exist and they can be great tools for us and they can offer great benefits to us, but they come with risks and challenges and potential problems. And, as this quote says, sometimes using technology or using it in a particular way might not be the answer. And sometimes it pays to stop and think a little bit before you actually implement things. And that really goes to the heart of a lot of what we're going to talk about today, I think.
Absolutely, and I think that's a really good point, Ian, that although we're talking about AI, this this logic and this quote does apply to technology adoption in previous years, and for any organization that's looking to adopt some sort of technology tool to give thought to everything we're talking about today, because I think it's relevant in so many ways. So what is AI? Essentially, it's technology that's enabling computers and machines to simulate human behaviors and comprehension, problem solving, decision making, creativity, and autonomy. And although the explanation and the definition can go much, much deeper than this, essentially what we're talking about is applications and devices that, when equipped with AI, can see and identify objects, understand and respond to human language, learning from new information and experiences, and acting independently, replacing the need for human intelligence or intervention. And some of those statements are probably quite scary in terms of what does this actually mean to us in terms of our roles in the future and for people entering the jobs market, etc. So I think we're all conscious of the significance of AI and what it means to the world and how it's already impacting organizations. And this is no more evidenced, I think, than some of the stats I'm about to share, and I'll invite the panel to share their own thoughts on these. So what we're seeing is from McKinsey, a very recent study, October of this year, nearly 80% of companies report already using AI. And then we've got the Tech Radar survey, which is showing the use of AI backed by tech consumers. So these are the tools that people are actually using in the workplace already. And we can see, a very common one right at the top of that list. And then a very interesting study from MIT, again from this year, where they've reported that 90% of employees are using ChatGPT every day in the workplace, and yet only 40% of employers have actually given access to those AI tools. So I think there's an awful lot of context and breadth to be taken from some of the stats on screen, and I'd be interested in the panelists' thoughts on some of these.
I think
I mean, one of the
oh, go on, Peter.
technical terms that seems to be jumping out at me at the moment is this shadow AI, which it seems to be being used on certainly some of the podcasts I'm listening to, and that really does, those stats really do bear that idea out, that there really is a lot going on. And I think certainly my data protection colleagues probably have quite a lot to say about what that means.
And I think the figures reflect what we're experiencing with the organisations we work with. So they'll often come to us and say, actually, we know staff are using these tools, but we don't know how they're using them or what they're using them for. And can we have an AI policy which puts in place some sort of governance around this? They won't always be being used with personal data, but there could be commercially sensitive information going out on these or through these tools. So I think it's just employers, organizations trying to get to grips with what's actually happening, because it's happening so quickly, and trying to put in place some governance and controls to make sure that they're reducing any risks that might come about. But in the context of HR, it's a very, very different kettle of fish, because that is absolutely personal data at the heart of it.
Yeah, and I think that the bottom sort of stat for me is the kicker, isn't it? 90% of employees are already using ChatGPT specifically daily, even though employers haven't decided which one they're going to use or formally given access to it. And of course, ChatGPT in particular, when you're thinking about sort of information security, data protection type things, public facing, if you're just using the basic web browser version of it, you don't know where that data is going. And as you said, Megan, you don't know what people are putting into it. It could be personal data, it could be commercially sensitive, it could be anything. And yet employers are sort of lagging behind a bit there in terms of the controls versus what employees are already doing. So I think there's clear risks there, and that's why we're seeing such an uptick in sort of people coming to us asking for advice.
Yeah, absolutely. I think as well the fact that we're seeing such a rapid and high rates of adoption, so, like 90% on that MIT stat, that suggests to me as well that it's a lot of that is because it's so easy to use, perhaps, and it's people have been able to get used to using it very quickly, and I think that's why they may be ahead of where their employers are at in terms of permissions, etc.
Yeah, and I think being browser based helps it there, doesn't it? Because you can just go to the web page and ask it whatever you want, basically. So
yeah, absolutely. So that kind of sets the scene in terms of what AI is, and we can see some pretty dramatic statistics and data there in terms of the adoption rate and the trends and the types of tools that the organizations and staff are using. But we're going to go a little bit more granular at this point and talk about in particular the use of AI in recruitment. And for this section of the webinar, I'd like to invite Peter to kind of comment on some of the stats that we're seeing on screen and sort of to draw on his experience and knowledge about what he's seeing.
Yes, thanks, Rich. Well, I won't go down this list and sort of read out all the stats to you, but you can see there really, and these aren't, I don't think, as definitive as the previous slide stats, but nevertheless gleaned some of it using AI, funnily enough, and it's quite obvious that there's a lot of it going on. There's a lot being used in recruitment, interviewing candidates, and there's one interesting stat at the bottom there, and have no idea how accurate it is, about 1% of hiring managers relying on AI to make the final hiring decision. You kind of hope that that would be perhaps zero, but maybe if it is being used more than that, then people aren't willing to admit to what they're up to. But the reliable stat at the bottom, I think, is possibly the most interesting one, which is on the positive end, which is that everybody is saying, well, most people are saying that it's really helping efficiency in terms of recruitment. And so there's a very good reason why you'd be wanting to use it. And so then the question is, are you doing it in the right way?
Yeah, I agree, Peter. I think that bottom stat is really telling, because I think efficiency is something probably that most organizations, regardless of the discipline, are looking to improve. But I think the one probably that probably surprised me a little bit is the second stat with a 30%, based on the fact that being a 2023 stat. So this isn't this isn't brand new, is it? This has been going on for a while.
Yeah, absolutely. Now, this is, I think, for all the HR practitioners here today, I'm not once again going to read out the slides to you, but all of the obvious uses for AI, I think, are set out there. Some quick and easy drafting, screening, interviewing. We'll come on to some interviewing related issues a little bit later. And the obvious ranking, and just thinking about the quality of the output there, I think is the key point in whatever area you're using it for recruitment. And of course, as we advertised, in dismissal, which is moving on to something which perhaps isn't quite as obvious to people on the next slide, which is how AI is being used to monitor performance. So that's actually being able to pick up the performance in the first place, and then clearly applying algorithms to evaluate that performance. And possibly then, as a result of that, and possibly within the context of quasi or actual objective selection from redundancy pools, for example. So there are a lot of uses which perhaps not quite so obvious, but I think are still happening. And I think from some of the examples that we've got here, I think that will be clarified. The first case that I've got on that list there was actually an Uber Eats case, and this was about the possibility that there was algorithmic discrimination on facial recognition software because a black worker was unable on several occasions to be able to log into the app using the facial recognition software. He brought a legal claim, employment tribunal discrimination claim, and very interestingly, the Equalities and Human Rights Commission got involved in that case. There was a preliminary hearing about whether or not this case should go forward on the basis that it was pleaded, and the judge supported it. So it was going to be a very, very interesting exploration into algorithmic discrimination in the employment field. But unfortunately for lawyers and everyone else, that settled very quickly after the preliminary hearing. So we never quite got to find out what was afoot. But I think it probably speaks volumes that that claim was brought and that the Equalities and Human Rights Commission got involved. The second one, a failed video assessment, and that was Estee Lauder, the MAC brand, and that was a restructure where there was a reapplication for own jobs. I'm not quite sure exactly the details on that, but that was the shorthand, and there were video interviews used on that occasion. The company said they only used it for a very small percentage of their assessment, but interestingly, these employees that were ultimately dismissed as part of this process were never told that AI was being used in relation to the assessment of their video performance. So I think that's a very interesting example of the transparency points that we will no doubt come back to on more than one occasion this morning. And finally, this is a broader point, and this is sort of Amazon bashing to some extent, because these the cases that I came across were Canada and US based, but there were issues around 200 employees bringing a US style action because they were disabled and their performance was being monitored, and they were effectively saying that their disabilities weren't being taken into account when that was evaluated. And there were some other issues around the evaluation of performance, and also actually dialing back to make the system less critical of employee performance when there were issues around union recognition. So some quite subtle and potentially manipulative use. Obviously, I'm not going to say that Amazon did anything wrong in that particular case, because I haven't looked into it in enough detail, but I think that's where the allegations lay. So, yeah.
Thanks, Peter.
I'll leave it with you.
Thank you. Yeah, and that's so interesting. And I think probably it's fair to say that the average job seeker will probably be completely unaware that AI is so prolifically used in recruitment. Ian, I think this one's yours.
Yeah. So I think this is really just a general point, really, that there is no, we don't have an EU AI Act equivalent essentially in the UK. Currently at least, there's no single overarching piece of legislation that governs how AI should work. You can see from the slide there are a couple of legislative options that are potentially going to make their way through Parliament. Whether they get passed or not, we don't know. And the government has issued some guidance on the use of AI in recruitment. So I think this is going to be a theme that we come to, apart from obviously the various related pieces of legislation that we're going to talk about. And if you move on to the next slide, which we'll see what they are. So whilst we don't have this overarching piece of legislation that says this is how AI works, in the context of recruitment and selection, you've still got things like the Equality Act, the Employment Rights Act. Data protection legislation will also apply, because you're clearly going to be processing personal data if you're recruiting and selecting individuals. And as I said on the last slide, we do have some regulatory guidance as well. In the data protection space, the ICO has published some fairly meaty guidance on the use of AI, which covers various things around sort of lawfulness, transparency, and explainability, and things like that. So whilst there is no single overarching piece of legislation, there are still all these other disparate pieces of legislation that cover lots of different areas, and not just data protection law. And you've still got to comply with all of those pieces of legislation, when you're using AI in a sort of recruitment and selection perspective. So I don't know if you want to move on.
I added this one on the end, really. So in terms of those, what does human rights maybe come into that side, into the use of AI?
I mean, I'm quite happy to let other people have their say on this, but the obvious one would be, if you're a public authority, then you have to act in accordance with individuals' human rights, and so the use of AI still has to comply. And of course, data protection law stems from the right to privacy, which is in itself, one of your human rights. So there's going to be some overlap and interaction there. Of course, I don't know if anybody else on the panel's got some thoughts on that.
I think on a slightly more subtle legal point as well, if you're sitting in front of the judges and there's an argument about the way that the law should be interpreted, then they're going to apply the Human Rights Act to that interpretation. This is an emerging area, and cases such as the Uber Eats case, it may well be that it was just a straightforward Equality Act case, but of course we're talking about a relatively uncharted territory. So I think the basic idea is that human rights and obviously all protected characteristics and favourable interpretation when it comes to protecting human rights is going to be at the forefront of any case law that we do see emerging in this area.
Yeah, thanks, Peter. Megan, I think this one's for you, isn't it? In terms of the anti-discrimination law.
Yeah, just looking at really focusing in on the data protection side of things and where AI might be used, or where we're seeing it being used in the context of recruitment. So it can be used at that very initial stage of screening applicants, when someone submits a CV online. It can be then used further on down the process for assessing and scoring, and that could be in the context of just on the documents, or it could be in the context of video interviews as well. There's some emotional analysis that could come into play, and we know there's some products that do and can do that in terms of video evidence, and assessing performance in terms of the wider sort of issues that may culminate in someone being fired. So it can be used at many different layers and in different ways by organizations. So it is a complex piece.
Yeah,
Can I just jump in very quickly as well on that and highlight the fact that emotional analysis, and except in very special cases, is actually banned under the EU AI Act. So you are actually talking about something which is really does stir people up, and it's quite a significant issue. I think it's possibly because it's an unreliable system in the first place, but it's certainly on the banned list when it comes to the EU.
Yeah, and I know from talking to sort of friends, peers, colleagues, etc., people are concerned about the fact that they're being screened in certain ways through the use of AI and maybe not being successful in their job applications when they maybe feel they should be getting interviews, etc., and they're beginning to wonder whether there's some sort of bias going on in the background.
I hope they don't do that with webinars.
So in terms of data protection law, and I always say the primary sort of thread running through data protection law is no surprises. People should not be surprised in terms of how their personal data is being processed by an organization. So that forces you down the transparency route. You have to be open and transparent with the individuals you're dealing with. This then links into fairness. So you have to be transparent as part of ensuring that you're being fair. And then with accuracy comes into play as well. And you have a right not to be subject to a solely automated decision that has a significant legal effect on you, or a significant effect. And that can be, we would argue, in the context of recruitment. So there are some exemptions to that, but broadly speaking, you have a right not to be subject to an automated decision. So as an individual, you can ask for a human to actually intervene and reassess that decision for you. But they're sort of the key threads running through all of this that are relevant in the context of recruitment.
Yeah, and the final bullet point I always find interesting recently, because it's never been more relevant than now, is it? In terms of it's been something that probably might not have been so relevant as a right maybe sort of 7 years ago, but with the AI, it's coming into play, isn't it?
I know when I first started in data protection, back in the day, as we say, there was, I think it was Section 12 of the 98 Act was about automated decisions or something like that. And at the time I was like, what's this for? But now, of course, absolutely, now we're right in the eye of the storm as far as this sort of stuff's concerned. So it's this in that bottom point is not new really from a data protection perspective, but it's much more relevant now than perhaps it's ever been.
Yeah. I would agree.
Yeah, absolutely. Peter, I think this is probably one for you to pick up.
Yes. You probably hear me say burden of proof far too many times on this slide, because this really is the issue with discrimination cases. And if we go back to, for example, the Uber Eats case, where somebody was not able to work as a result of the automated decision making of an AI-driven facial recognition system, and whether it had discriminatory impact. There's the concept of burden shifting in discrimination cases is absolutely fundamental. Once there is something more, once there is an arguable case that or basic fact has been proved from which discrimination could flow, not does, but could flow, then it becomes the legal duty in the case for the employer to explain that it wasn't discriminatory. And that's the burden, and it's a very heavy burden. And if you don't have documentation to support it, as I'll and I will labour this point because I think this really is the one, then that's when legal liability might land in your lap and stay there, regardless of the fact that you didn't know you were doing it and you didn't intend to. And that's the really difficult point, particularly with indirect discrimination, where you treat everybody the same in inverted commas, but it comes out badly for a particular group. And another absolutely key point, and I'm sure all the HR practitioners and pretty much anybody that's in business will understand the difficulties of ensuring that you don't discriminate against people with disabilities, which may be hidden. There may be neurodivergence in particular, but there could also be sight and hearing issues using automated systems, video-based systems, etc. And so, thinking very carefully about groups that might suffer ill consequences as a result of using the tech is of prime importance. And once again, if you haven't considered those things, then under the indirect discrimination rules, particularly, you don't need to know that somebody has a disability in order for you to be found liable for having not thought about it and done something to mitigate the discriminatory impact. So yeah, you can get some surprising and unexpected, unwanted litigation coming out of AI use in the recruitment and dismissal spaces for sure. Yeah, so I think that pretty much covers it. Yeah, evidence of fair processing, but that comes back to a data protection point, of course.
Yeah, absolutely. And going right back to the Jurassic Park slide, I suppose, in terms of considerations when adopting and implementing the use of AI, and this is the sort of the due diligence, the preliminary sort of thinking in terms of what do we want to use and why do we want to use it, and then considering the implications of that. Because as I said, we have organizations and clients, for instance, that are already using it and then retrospectively starting to think about what that might mean. So Ian, I think your thoughts on the transparency considerations.
Yeah, I think just interestingly though, Rich, there's a question in the Q&A that sort of talks about, but the UK could use emotional analysis, couldn't it? And that Jurassic Park quote's really good for that. Unfortunately, yes. I think they missed it, but they'll get it on the re-recorded version. That whole idea of, just because you can doesn't mean that you should. No. Yes, the EU AI Act doesn't apply to the UK, and there is nothing in the UK at this point in time that explicitly prohibits the use of emotional analysis. But as we're going to talk about probably now when we get into the lawfulness aspects of it, lots of data processing requires you to be able to demonstrate that what you are doing is necessary in pursuit of the legal basis that you pick. It's not enough to just say, I have a legitimate interest, or there is a contract involved, or I have a legal obligation. You have to show that the processing of the personal data that you are undertaking is necessary in order to meet that legal obligation or to fulfill your legitimate interest. And actually, legitimate interest is a bit more complicated, as we'll come to onto the next slide. So, yes, in theory, the UK could use emotional analysis, but actually there are still legal hurdles to get over, not least from a data protection perspective on that point.
Yeah. I mean, that whole subject sort of underpins our work as an outsourced data protection team, doesn't it? Because data protection isn't all about compliance. It's about best practice and culture and ethics, and completely, as you said, the Jurassic Park quote absolutely nails it. So hopefully people who've missed that will be able to catch up on the recording.
So I just wanted to talk a little bit about, that first point on the last slide, though, about, you don't have to go back there, which is fine. Do you understand how your AI system works? It is the first question that I will ask any client that comes to me that says they are using or want to use AI, because if you don't understand what the system is doing or how it's doing it or where your data is going, we talked again earlier on, it will be in the re-recorded version about how ChatGPT works, the fact that so many people are using it. I think we said something like 90% of staff use ChatGPT, even though only 40% of employers had actually said what AI tools people could use. And of course, the free browser-based version is just You know, your data goes off into the ether. It goes off to OpenAI, and they can do what they want with it. Yes, okay, the enterprise editions may have slightly more technical controls in place, you know, but people I don't think understand this. And if they don't understand it, how can you implement risk mitigation measures or even understand the risk of where your data is going and who you're sharing it with? And that second point about, which really links into what Megan's going to talk about around sort of broader fairness and explainability, so I won't touch on it too much, but being able to provide the envisaged level of detail around how AI works and what it does is impossible if you don't understand if you don't understand how it works. You know, so if you've got to take the time to, which is really what that Jurassic Park quote is all about. It's not saying
Mm.
no, it's just saying take the time to understand what you're doing and the consequences of what you're doing. You know, a simpler version would be don't just jump over the wall, go and have a look over the wall first and make sure it's not a cliff on the other side. You
Yeah.
know, so that's one bit on that. In terms of the specific lawful grounds that we sort of talk about, I've mentioned a couple. You know, obviously the contract again is one that people might look at as being relevant. But again, you know, there is no, you know, there's no contract in place. Yes, you may be taking steps to enter into one, but still, is the use of AI necessary for the performance of that contract or for the taking steps to enter into a contract? And by that, the ICO would say, have you considered all other options and have you properly understood and documented why those other options are not suitable? You know, and I would advise anybody, even though it's actually dealt with under the legitimate interests basis, which we're going to talk about in a minute, go and read the Serco enforcement notice that the ICO published last year, which is more about facial recognition, but it's got some good analysis in there about how you approach that necessity question, which is still going to be relevant for a lot of this stuff. Consent, I would argue, you should not be relying on in this context because you cannot be freely given. If I'm applying for a job, I don't really have any realistic choice about how you handle and manage that process. And if I say I don't consent to the AI being used, chances are my application goes in the bin. And even if that's not true, I probably think that's what's going to happen. So actually, I have no realistic choice. And on the legitimate interests point, as we've said, it's really going to come down to both the necessity test, you know, is the use of AI actually necessary? Is it the best and least privacy intrusive option available to you? But also, I think this is a good example of where that legitimate interest assessment that sometimes can seem very simple and somewhat of a foregone conclusion in a lot of cases is not. You know, the more privacy intrusive something is, or the more significant the potential outcomes for individuals are in terms of the processing that you're undertaking, I would suggest that organizations should be conducting a much more thorough, detailed legitimate interest assessment, properly taking into consideration the impacts on individuals, and particularly considering, you know, and I know Peter's going to talk maybe in a bit about, you know, vulnerable groups or people with disabilities or other people who may, you know, who may be impacted in ways that you've not thought about through the use of AI, you know, and all of those things have to be factored in when you're making that decision about actually is what we're doing not just necessary, but is it actually unwarranted because of the impact it's going to have on individuals, you know. And if you haven't documented
Yeah.
all this stuff, you know, even putting sort of like the potential future employment law issues aside that I know Peter's going to talk about, you're opening the door to all manner of data protection problems anyway. You know, you may not even have a lawful basis if this isn't properly documented. So, and you fall at the first hurdle at that point. So it's really important that you
Yeah.
document all that stuff.
I think that I suppose the extra sort of complex dimension to add to this is the commercial aspect, isn't it? Is that when it taking all of these things into account and doing the right things while potentially being aware that your competitors are doing all this stuff without caring, and the commercial advantages they might be getting, I guess. So it just
Well,
adds that
it
that
does,
layer.
but I would say to anyone who thinks that, you know, if you ever get done for speeding, tell the police officer that everyone else does it and see how far it gets you.
Yeah, yeah. Obviously, I'm playing devil's advocate, and that's a
Yeah,
great example. Yeah.
you know, because it won't get you very far. I can tell you that, you know.
No. Yeah, precedent is not compliance. Yeah.
Absolutely, yeah. It's all about your own individual justification for using it.
Yeah, sure.
And fairness, which is my area of interest in terms of treating people in the right way. So ethics comes into this, transparency comes into this. it is very tricky in the context of AI in terms of how can you be absolutely sure you're being fair. And it links back into what Ian is saying about documenting and thinking about it. What's the problem that you're trying to resolve by introducing AI into the process? How do you test that it's not biased? So if you buy an off-the-shelf product, if we can call it that, how do you as an organization, how can you reassure yourselves that there's no bias going on? How do you do those tests yourselves? And then linking into that, how do you explain how it's working to individuals? That is really difficult because it does get quite technical. And how do you ensure that people can exercise their rights around this processing as well? Again, quite a challenging area. But individuals, as I said previously, have a right not to be subject to automated decisions. There are some exemptions to that, which Ian touched on. So in the context of a contract or where consent is given, the new legislation that's just come into play this year, the Data Use and Access Act, has provided some additional safeguards that organisations need to ensure are in place around automated decisions that produce legal or significant legal effect. So you are required to give individuals information about how your decision making occurs in this context. You need to enable individuals to make representations, and you need to make sure that there's human intervention at a point in the process. So that is adding on some additional safeguards to protect individuals in this context. And I always highlight the example of LinkedIn, and many of us will have applied for or know people that have applied for roles through LinkedIn. And we suspect there's AI going on in the background, but we don't know exactly how it's being used, or if there's some bias going on. Is there an age bias going on with the algorithms? We don't know, but gut instinct tells you that there's something going on there that we're not really fully able to understand because of the explainability points. So it's really important for organizations to get this right. You want the best candidates, but is this the best way to do it? And that's something you need to think about.
Yeah, I think that's absolutely spot on, and I think we've talked a lot, haven't we? Where we've seen people on LinkedIn that say they've applied for 300 jobs in some instances, and they know that by the rule of averages they would have been successful in at least getting interviewed for some of those, and they never hear anything again. And so yeah, they're suspicious, I think, of what's actually going on, and it may be that the companies that are recruiting through that route also don't know what's going on. And how what's being presented to them is being generated.
Yeah.
Looking at the dismissal end of the process as well, and the redundancy selection point that came up in the Estee Lauder Mac case, the three people that were interviewed, Estee Lauder said that about 1% of their decision making was based on the video interviews that had AI attached to them. But a big point in that case, certainly in terms of the pleadings, was that they didn't know it was happening. And that was, I think that's pretty fundamental, and obviously underlines the point that it's happening in the real world at both ends of the process.
Yeah, absolutely. I've touched on this in terms of the safeguards that organizations need to have in place. And this could be significant in terms of processing. If you've got every individual that applies making representations, and you're having to explain in detail, you've got to have a human intervening in the decision, and individuals can contest those decisions. That's a whole other process that you need to think about in terms of people exercising their rights. So yes, there's data protection issues here, but I guess more significant in some respects is the fact that individuals can challenge it legally through different legislation. So yeah.
Yeah, so thanks everyone. So in terms of, I'm going to do something that we deal with as a data protection team is risk and risk mitigation and risk management, and obviously what today we're talking about is the risk of implementation of AI. So these are going to come in one by one, and I'll invite the whole panel to just comment on each as they see it. So in terms of an organization being unaware of how AI is being used for candidates and employees potentially excluding or dismissing individuals based on those untested algorithms is a huge risk.
I could certainly jump in and just say bias discrimination. And if you don't know you're doing it, but you're doing it, but you haven't got documentation to show that you didn't check, then there could be trouble ahead, and injury to feelings for discrimination cases, as well as potential loss of earnings claims, as well as obviously reputational risk as well. So just looking at the potential costs, they go beyond financial.
Absolutely. I think Megan, you've just touched on this one.
Yeah, it's really important to have a human involved. And AI is not perfect, and we need to have that human intervention there, and that helps to comply with individual rights as well in terms of that decision making. And I don't think organizations would wholly be happy with the no human being involved and solely automated decisions being made about people. I think that would be a very very risky process, way of dealing with this.
Yeah, absolutely. Yeah, and this isn't so. This one doesn't really. It's not solely about AI, and this comes across all sort of tech adoption. I think is that due diligence, not being undertaken on platforms and tools. I know as a team we're being asked increasingly by our clients to help them to be more confident about the tools and the platforms they're using or considering using.
I think for me this one is everyone just wants to use the new shiny thing,
Mm.
and but nobody really well, very few people I think really want to understand how the new shiny thing works, because we all want the benefits of the new shiny thing. So we all implement it as soon as possible because we want the good stuff. And we don't take the time to really understand. It is that Jurassic Park point, isn't it? It's the John
Yeah,
Hammond, how can we stand in the light of discovery and not act point? In other words, how can we have these things and not use them? They're so good. They give us so many
yeah,
efficiencies versus the Ian Malcolm point of, yeah, okay, but have you thought about the implications of what you're actually doing?
yeah, yeah. And with every innovation in history, there are pros and cons.
So yeah,
Yeah.
we've
So
touched on
go on,
this.
sorry, Megan.
I was
Yeah,
just going to say the explainability point, that's really important. And internally, if your organization is using it, you need to be able to understand how it works so you can explain it to, colleagues as well, because colleagues may be using that
yeah,
system to apply for internal positions as well. So
yeah,
they need to be made aware of how it's used.
This does
yeah. I
this
mean,
does
go
raise
on.
quite a huge point in the sense that even high level regulators, to the extent that we don't have an AI office yet, but we may well do in the future under legislation, it's difficult for regulators to actually understand how these systems work really and so
Yeah,
fast.
and I think
And
yeah. Sorry.
it's a real hot potato. And certainly we're talking about individuals, companies, or HR professionals, whoever it is that we're are going to be times. It's an onerous responsibility, but I think due diligence, I think, is probably the right terminology. That reasonable efforts need to be made.
I mean, it ties into the accountability principle as well, right? So from a data protection perspective, the law is explicit. The onus is on you as the organization to demonstrate how you comply with data protection law. So if we're talking about transparency, fairness, explainability, lawful processing, whatever it is, the onus is on you. So this might sound like a lot of work, but to go to that point about complaints to the regulator and or the legal system, because of course people have the right to seek compensation under data protection law as well. So it's not just employment claims. You might get a double whammy of an employment law claim, and they'll just throw a data protection compensation claim in there as well because they can. The numbers start to mount up, and of course from a data protection perspective, they will point to the accountability principle and say, well, come on, organization, show us your documentation, show us your working out, because you're legally required to do so. So if you haven't done all the due diligence and you don't understand how anything works, you can't explain your decisions, you can't even explain them to a court or a regulator, you're going to be in a very sticky position, I think, as and when those
Yeah,
claims come in.
There's a
yeah,
technical point as well around compensation, isn't there? And even under the data protection provisions, which is that you don't need to prove that you've been damaged by the breach of the law. That your belief that what has happened could have led to downstream
But
consequences that
I,
are upsetting and difficult for you is actually enough. And
I mean,
that's
yeah.
quite an interesting point, because it doesn't actually have to have led to a runaway train crashing.
Mm.
No, you
It's
don't. It's not just material damage under data protection law. No,
yeah.
you've got distress as well and things
Yeah.
like that. So, and again, the onus is on the controller or processor, the organization, to show that actually they weren't responsible for any breach that may or may not have led to said damage or distress. So, the onus is very much on the business, the organization, to get itself out of jail effectively.
yeah. Would you say, just sort of open question really, that we've spoken about the speed of adoption and other technologies being comparable, but I think it's possibly the case that when you look at the sort of speed of adoption of ChatGPT, for instance, and how many users were using it year on year in that sort of first 18 months, and the speed that organizations are adopting it, I think it's fair to say that AI is probably the greatest example of the most rapid adoption with the least amount of understanding. It just seems to be so fast, but there's so little understanding by the organizations that are using it.
I would say my anecdotal view of that is yes. I mean, obviously, I can't point to
Yeah.
any strong
No.
evidence that I've personally experienced, but I do feel like lots and lots of people are jumping on the AI bandwagon. And I reckon if I asked 90% of those people, have you done a DPIA, have you done a data protection impact assessment, I reckon probably not far off 90% of them would say, no, actually, we haven't.
Yeah.
Probably not far off 90%. They don't even know that their staff are using it.
And the other thing is they don't think of it in the context of them being a processor on behalf of the organization as well, in terms of it being an application or a tool that organizations could use. So that leads to another sort of raft of requirements around having the proper contracts in place and limits on how that processor can use their data, that type of thing.
Sure. Yeah. In terms of potential complaints to the regulator, I suppose it goes back to Megan, what we were saying about people being even aware that their data is being processed in this way, doesn't it?
Yeah.
Yeah. So you can't complain about something you don't know.
Correct. So yeah, it's a difficult area, but yes, the regulator, you have a right to complain to the ICO in the UK around breaches or concerns about the handling of personal data.
Yeah. I think I'll put them all on screen in one go. It's probably easier for everyone to sort of comment on what they'd like to pick up, I think. So in terms of AI systems trained on historical data?
I mean, from my perspective, that is central to that sort of understanding how your AI system works and, understanding what it's been trained on and the importance of testing. Again, like, I don't know how many people actually do a sort of what the ICO calls the research and development phase, where, you basically test and scope out the use of your AI before you do it. I suspect not many do, because as we've just said, the speed of uptake, everybody just wants the cool stuff. So yeah, I think my view is on that one is it's central to that idea of understanding how it works is also what is it been trained on, and have you tested it for bias so that you're not going down the route of either unfair and or unlawful processing of personal data.
There was a particular case actually a few years ago, and I hesitate to say it was definitely Amazon because I'm recalling it now, but there was a gender bias within the training data that the organization had actually put into the way that they were processing their selection. I think back in 2019. So I mean, this is a long time before the mainstream uptake that we're talking about since 2022 and ChatGPT, and they abandoned its use as a result of, I think, the finding that there was unwanted consequences based on an innocent use of extending bias that had already existed in their system. So they were trying to use the system to remove bias, and actually they trained it, I think, as I understand it, to nail it to the wall. So yeah, not great.
Mm-hmm.
I was thinking about vulnerable
so many of these risks
people as well. Yeah,
consistent in the theme.
Yeah, and that's part of doing an impact assessment, is looking at who may not have access to the tools as well. Sorry, that cut out then. Yeah, so looking at, as part of a wider assessment, how vulnerable communities may be impacted by this in particular, and doing that really broad brush approach in terms of, particularly in the context of recruitment, because that's where it is increasingly being used. So it's really important to do a data protection impact assessment.
It's kind of an all-encompassing thing, isn't it? It's on the one hand, how's your tool working? What does it do? What data have you trained it on? And on the other hand, who is going to be affected by this? Is it, are there vulnerable people in there? Are there people in there with disabilities or other reasons who may be disadvantaged or may not be able to engage with the process in some way? And would they be unfairly treated as a result of that? You've really got to kind of look at this in the round. Which again is a lot of work, but the expectation is that organizations do that work prior to implementation.
Yeah, absolutely. So we've looked at the risks and obviously we've talked a little bit in conversation really about how to reduce those risks. But yeah, if Ian, would you? I mean, for those on today's session who aren't familiar with data protection impact assessments, maybe it would be good to sort of briefly summarise what they are before we move on to the other measures.
I mean, it's a risk assessment essentially, but it's a
Yeah.
risk assessment that is designed to look at all aspects of specifically sort of data protection compliance, although, you might factor in other areas of law into it, particularly when you're assessing the lawfulness of your processing. In this context, you might need to look at the Equality Act or employment law and things like that. But a DPIA in a nutshell is a risk assessment that looks at all aspects of data protection compliance and requires you to think about them in advance of actually doing the thing, so that you can then identify and document any risks, come up with remedial or mitigation measures, get them documented, signed off, and implemented, so that then you can do the thing and you are at least aware of any risks that are left, and that you've taken steps to sort of mitigate them as much as you can.
Yeah, brilliant. So if I'm looking at these bullet points through the lens of, for instance, the HR team that's looking to potentially adopt some AI tools for its recruitment processes, the risk reduction measures can appear probably quite overwhelming, especially in terms of the technical side of it. And so, it sort of tells me this isn't a quick fix. This isn't something they can do in a couple of days just to tick some boxes. So are we sort of thinking here that who would be the individuals within those organizations that would help them to make sure this stuff is done? Are these sort of technical security experts or data protection professionals like ourselves?
I think it will be compliance people within that organization. So that data protection would fall into that, InfoSec, possibly cyber, people, depending on how the system works. HR would obviously have to be center to all of that as well. So yeah, and that's part of what happens with the data protection impact assessment. It forces you to go down that consultative route, and also consulting with the people that might be affected by it as well, and maybe testing it out that way before you actually roll it out as the platform that you're going to use for recruitment. So yeah, there's a lot of consultation required and input required before something goes live.
Yeah, and in terms of adopting and regularly updating AI policies, I mean, this is something as I said before, we're doing a lot of work with clients at the moment. It's almost as if the legs are running faster than the body, isn't it, in some instances? And all this stuff is adopted and is in daily use before any consideration of policy updates.
Yeah, I mean, it's sort of, it's compliance 101 almost, isn't it, having a policy, and it goes to that documentation point of, have you set the ground rules for, what tools are acceptable, which ones aren't, how they should be used, when they can't be used. It's all the usual stuff about having a policy. But as you said, Rich, the speed of uptake is so fast that half the time people are using it before the business even knows they are and can put a policy in place.
Yeah.
I think there's, I mean, in terms of the UK position, and it's quite distinct from the way that European Union are doing things, is that we've got this cross-cutting principles-based Equality Act and data protection within the AI regulatory framework, and so that cuts across everything in a very general sense, but with little specificity, a lovely lawyer word, to exactly what that means for you as an end user, in the workplace. And I think certainly in regulated areas, and this will be legal profession, financial services, certainly, Competition and Markets Authority will become involved as well. I think there's going to be an increasing amount of more specific guidance and perhaps statutory guidance that has legal effect coming into play. And I think that's really the basis on which the UK is approaching this, which is a much more similar to the way that I think things are being done in the US. And I think the fear is that if you try and clamp down on it with too many specific laws, it stifles innovation. And so, I think there is going to be a lot of regulatory action growing up to try, hopefully, to give everybody a much clearer idea about exactly what they should be doing. And of course, providers will be being able to provide tools and processes and procedures, and obviously data protection is going to be a huge part of that. So
yeah. I mean, we had a question pop in about which stakeholders should be involved in all of this, and I think we possibly might have answered that through the chat, really, in terms of the InfoSec people, cyber. It is a real sort of all business effort, isn't it?
It's multifunctional.
Yeah.
I mean, you're going to need technology people, compliance people, HR people,
Probably legal as well, I'd
probably
say.
legal.
And
No,
not
you
to
don't want
Pete
them.
there.
So, but you want a project team, and you want input
Yeah.
Yes.
from various different stakeholders, from technology, HR, compliance, legal. There may be others depending on the specifics of what you're actually trying to implement. But absolutely, it's a multifunctional approach.
Yeah. So some more risk reduction measures. I mean, updating privacy policies again is something we're very busy with clients at the moment, and organizations that aren't our clients also approaching us. Yeah, and again, it just comes back to that, who's involved, who should do what, involving HR teams in the policy and the ethics and the legal obligations. So this is you could almost say this is a real game changer in terms of how professionals are working within businesses, and something that is now going to be part of their awareness or skill set going forward generally.
Yeah, I think so. I mean, I think if you're going to be using it, you need some sort of baseline understanding of what you're trying to achieve, how the tool achieves that, what you can and can't do. We don't all have to be real detailed technical experts on it. That's,
No.
That might be what your technology teams are for. But yeah, I mean, if you're going to use something, you should at least understand what you're using and how it works, right?
Yeah, absolutely. On the final point, in terms of offering alternative application methods, would that need to go hand in hand about, obviously, Megan talking about transparency and fairness, the being completely upfront about the process is AI driven, so therefore there is an alternative has to have two or more options, doesn't it? So there's a lot of
Yeah, I
transparency
mean,
there.
yeah, it's something to think about. Again, that would come into play when you're assessing the whole process and what's actually going on. So you may, as an organization, want to offer up an alternative process for people, but that'll be down to the organization in terms of whether that's fair, ethical, all the rest of it.
Yeah.
I think that's
Brilliant.
kind of
Thanks,
it's the two things. It's the sort of automated decision making stuff and needing to have those safeguards in place, and almost the sort of reasonable adjustments point that you might have to do under sort of equality law as well. But it all ties into that last bullet point, I think, about giving
Yeah.
people another option, another way.
Yeah. Thanks, Ian. Yeah. So in terms of the session as a whole, there's so much to unpack here, I think, and we will be answering everyone's questions, and they can approach us after the session. If there's any, normally in these kinds of sessions where there's a lot of very specific scenario questions that come in terms of, we're doing this, how should we be doing it, etc. What should we be thinking about? But the panelists have all provided what their sort of primary takeaways are from today's session and this subject matter as a whole. So Peter, I'd invite you to sort of to talk us through your takeaways from today's webinar.
Yeah, absolutely. And there's a bit of repetition here, but say it 3 times, I think, is probably the rule on a lot of this stuff. Equality Act applies to algorithms. That black box that you put information into and something comes out, if it's a discriminatory algorithm, then you're responsible for the output in the end. Obviously, dismissals must be fair procedures must be followed, and that's whether it's dismissals or obviously on the recruitment end. And this human oversight, I think, is really the human in the loop, as the jargon goes. I think is a huge and very important protection for you. But the human clearly needs to know what they're doing and why they're doing it. And I think just that last point on the next bullet is that ensuring regular staff training, and I think in particular, obviously, users and anybody that's going to be really closely involved in the recruitment process. I think it's an expansion of the recruitment training to make sure that those who are involved really understand the tech that they're getting involved with, and it may be that you would need some form of specialist input in order to bring that up to a standard. I don't think employers are going to be required to become tech experts, but at the same time, there is going to have to be a convincing story, and if called to account in an employment tribunal, a little bit like your diversity training having been 5 years out of date when the manager made a decision they couldn't quite explain, I think you'd be in the same territory here if you've got an algorithmic discrimination claim coming through, if you haven't really looked at what you're doing properly. And I keep coming back to this point, but it's not law, but it is commercial risk. It's the ethical use, and actually getting the right candidates is partly about being an attractive employer. And just on the HR end, actually having transparent processes, having fair processes that use the tech in the right ways, absolutely, but avoid the downside risks of using it in the wrong ways or using it in ways that people don't understand and therefore fear, I think is probably a key factor, certainly from the strategic end of implementation.
Yeah, that's such a powerful bullet point, isn't it?
Yeah.
And trust is absolutely everything, and ethics is something we talk about as a team constantly, because I think that's one that Megan or Ian said previously, that there's so much focus on compliance that people lose sight of whether they should do stuff or not. Yeah, so thanks, Peter. Megan and Ian, your takeaways?
Yeah,
I mean, I think,
sorry,
oh, go on, Ian,
I
sorry.
was going to say, so obviously the first couple, I mean, data protection law, much like Peter's opening bullet point, data protection law applies to the processing of personal data, even where it's being done by AI tools. And the accountability principle would say you're responsible for making sure that that processing is done in compliance with data protection law. So, you can't get out of jail by saying, well, the AI made the decision, not me. Yeah, but you decided to use the AI. And I would argue it's, a DPIA may be required, possibly would be required in most cases, but you can't say for certain. But it's certainly advisable. If you look at things like privacy by design and default, and we've already talked about the significant risks to individuals about the use of this kind of technology and the need to show you working out and everything else if you go to court or you end up in front of a regulator. So for the sake of doing that data protection impact assessment, that risk assessment, even if you decide one is not legally required, you should do one. It's highly advisable that one should be done. I don't know if you want to pick up some more on that, Megan.
Yeah, I mean, it's really important. I think Peter's point really summed everything up. You want to be a good employer. So therefore you need to be able to explain this properly, but it's also just taking a step back and thinking about what is the problem we're trying to resolve here? Why are we using AI? Are we trying to make our processes more effective, more efficient? Are we trying to get the right candidate? Is that actually what's happening? Are you getting the right candidates? Are you discriminating? Are you going to end up in an employment tribunal? So there's a lot of thinking around this, and that's all we're really hoping that you'll take away from today, is that actually we can't just buy a product off the shelf and just roll it out and without thinking about it. We need to give this quite a lot of thought, and the risk needs to be owned at the senior level within the organization as well.
I just want to add one thing that's popped into my head, and it sort of popped into my head based on something Peter said about the Estee Lauder case and the idea that the staff didn't know it was going on. We talked about transparency and explainability a lot. Well, in their guidance on, I think it's their guidance on issuing fines, the ICO talk about the particular risks of what they call invisible processing. So in other words, processing that the individuals don't even know is happening. And as you rightly said, Rich, if you don't know it's happening, how can you can't even make a complaint, you can't go to court, you can't go to the regulator. So in the event that this comes to light further down the line, invisible processing is by its definition a higher risk to undertake, because the ICO will say, well, it was everything that you've done, you've not complied with all these other things, and that was made worse by the fact that individuals didn't even know it was happening and therefore couldn't properly challenge it. So that's something else to bear in mind.
Yeah, I mean, something that sort of comes to mind as well is, I suppose, moving away from the sort of compliance and the ethics side of it is I guess the importance of measuring the success of these tools, isn't it? And how do you measure that your recruitment activity over the sort of next couple of years, for instance, is successful because of the use of AI? Are you actually diminishing the outcomes? And I know that there's I don't know the percentages, but so many more CVs now that are presented to employers have been generated using AI, which diminishes a little bit of confidence and trust in around the accuracy of them, doesn't it, Megan? In terms of what we're actually looking at here, and when you're sifting CVs, you see such similar themes. So there's a lot of other sort of angles to this subject, I think, that aside from the compliance and the ethics side of things.
We do have a question in the Q&A from Pompilia about examples where AI usage within firing could be compliant and where not. And this is the less explored end, I think, of the AI use in the workplace. But certainly performance management is really at the forefront, I think, of most of what AI might be being used for, and certainly that seems to be coming through, particularly from the Amazon end. So what's compliant and where not comes down to all of the principles that we've been talking about. If you're monitoring staff and their performance without using AI, it may be that you would be needing to think about, or you should definitely be thinking about, whether disability is part of the picture, whether somebody has a hidden disability, whether there's neurodivergence, whether there's a dyslexia or dyspraxia. It could be ASD, ADHD. There's all of these factors can come into whether the standards that you're applying and the amount of flexibility that you're giving, or indeed the working methods that you're requiring people to follow, can influence whether or not they are able to perform. So it could be actually at root you're measuring something where somebody can't perform because you're not making the reasonable adjustments in the way that they work, as well as not making reasonable adjustments in the way that you're measuring the quality of or quantity of their work. So it's a terrible typical lawyer response to your question, Pompilia, but I will say it depends because there's a lot of subtlety in even that one strand of consideration. And of course, once you start talking about video interviews for restructuring, or 5 into 3, and you're trying to grade people in terms of pool selection. Is that going to be an objective grid, or is that going to be an objective grid plus an interview process that has some AI aspects to it? That's an open question as to, if you're transparent about it and the parameters that you're applying to measuring that interview process, you would need a great deal of consistency in the way that it was conducted, and you would also need to understand that the outputs were not discriminatory in themselves. So there would be an awful lot of compliance behind doing something like that, and doing it well enough to be able to explain how it wasn't discriminatory if it came up as an allegation.
Yeah. Thanks, Peter. Yeah, that was a great question. Yeah, and I guess from a again, devil's advocate perspective, we're talking about AI, but it isn't necessarily the case that analog or standard processes are flawless and lack bias either, is it? So it's this thing, isn't it? We're not saying that is the bias embedded in, because they're also in the analog systems as well. So
well, there's a tremendous irony there that actually employing an AI system which is devoid of human biases could actually be a way forward.
Yes.
But make sure that it is. But if it is, and you're using it as a significant filter that without human bias, then if you can prove that to yourself and everyone else, then actually that's potentially a huge benefit.
Yeah, I guess it's a little bit, I mean, I know that Megan and Ian know I love my analogies, but I guess it's sort of maybe overly focusing on accidents caused by driverless cars, when actually there's probably going to be less than the accidents with the people behind the wheel. So yeah, as a comparison. So yeah, so I think that's all of our questions for the moment.
I think sorry, Rich, I think there might be one just at the top. It says, surely HRA doesn't apply to companies that might have more money to use AI in recruitment. I think, and I'm sure Peter will correct me if I'm wrong though, that Peter made the point earlier on that courts will still factor human rights law into the way that they apply the law and make decisions. So it will still come into play there. And also, as we've said, data protection law kind of brings aspects of human rights law into the private sector anyway, because it is fundamentally about protecting people's right to privacy, and balancing that with the use of personal data for commercial gain. So, in essence, any contravention of data protection law is an infringement of someone's human right to privacy. And were it to get to a court or a tribunal or regulatory stage, that would be something that they could bring into consideration. So yes, Human Rights Act doesn't apply directly to private sector organizations, but throughout the process, it can start to bleed in. So it's something that you should still take into consideration, I think.
Brilliant. Yeah, good point. Thanks, Ian, and thanks for spotting that question. Yeah, so again, many thanks to all of our panelists for today's session, and some brilliant insights. With the recording, the full recording will be available on the YouTube channel on the Moore Kingston Smith website, and everyone who's registered for today's session will receive a copy of the slides and a summary of the questions as well. So yeah, all it leaves me to say is thank you very much for everyone that's joined us today. Thanks to our panelists, and hopefully to see you all again on a future webinar. Thank you.